Hi, my name is Nick Bolu. I'm a patent attorney. This video is about a question that comes up every now and then, and that is, do you need a prototype to get a patent? The general answer is no, you do not generally need a prototype to get a patent. However, there are some cases where it would have been useful to have a prototype, and those cases have generally been when the patent office or the courts are a little skeptical about whether or not an invention even is possible or works. In those cases, the patent applications were rejected, and it would have been useful to have a prototype. I found five of those cases. They are listed here. An energy generation system having higher energy output than input. Two, Vibracraft flying machine based on vibration. Three, controlling aging process in living organisms using isotopes. Four, using magnetic field to increase energy release of fossil fuels upon combustion. And five, compositions of matter for curing cancer. This presentation, I'm going to review those five court cases, and then I'm also going to talk about a little bit of recommendations and practical advice for when you should have a prototype or when it would be beneficial to have a prototype. My contact information is listed on the right here. We have my LinkedIn, YouTube, and email if anyone wants to get in touch with me. Example one, energy generation system having higher energy output than input. And I put that in quotation marks because that's the actual title of the patent application. On the right-hand side of these slides, I put a screenshot at the beginning of the court case. It has the case site, the years, the court, in case anyone wants to look these court cases up. I think these are all relatively interesting court cases. And then on the left hand, I've mainly put an example claim and then a part of the opinion that I think is the most interesting. Okay, example claim 43. The method of producing usable energy comprising the following steps: inputting energy into a device from an external source, having electrical current flow within said device, and utilizing the internal electromagnetic energy of at least some of the matter and the device to add the energy being input into the device from external source to produce useful energy for outside of the device having an amount greater than the energy of input to the device. Accordingly, this method is saying that it's producing more energy than is input into the system. The court said the claimed device was a perpetual motion machine, and the perpetual motion is impossible for it violates either the first or second law of thermodynamics. The decision of the district court that the claimed invention is unpatentable because it fails to comply with 35 U.S.C. Section 101 for lack of utility and with 35 U.S.C. Section 112 first paragraph for a lack of enablement is affirmed. Accordingly, the court said that this is for a perpetual motion machine. They don't think that that's possible, and the applicant didn't provide proof of that. If he would have provided a prototype that would have demonstrated this, then he could have gotten a patent, but he didn't, so the patent application was rejected. Example 2, Vibracraft flying machine based on vibration. Example claim, and I say the full claim is not available. The part that was in the court case says, a vibrating member on said body adapted to engage the atmosphere surrounding the craft and means for vibrating or oscillating said member in a periodic manner with vertical components such that, and then it listed some different differential equations that the fluttering needs to satisfy. And the equations were based on the fluttering of birds and insects' wings. And the opinion says, appellant's counsel at oral argument stated that question was a matter of how much of showing should be required, and that because of the inordinate expense allegedly involved in producing a working model should not be required. We need not pass on this point, however, since the record does not indicate that the Patent Office insisted on a working model as the only acceptable method of proving utility. So that's showing that the inventor, he said that it would have cost too much for me to make a prototype, so that's why I didn't make a prototype. And then the court said, well, you didn't need to make a prototype. You could have provided other evidence that this concept would have worked, but you didn't provide any evidence, so we're not granting you a patent. Example 3, controlling aging process in living organisms using isotopes. Example claims. 1. The method of influencing the effective age of a living organism, which comprises modification of the abundance of a specific isotope present in such organism. Claim 12, the method of influencing a living organism which comprises modifying in such organism the abundance profile of specific isotopes of specific elements in a manner different than any attendant modification of the abundance profile of said elements, the latter profile taking into account all the quantities of isotopes of said elements which are present in such organism. And his patent application said that if you control the specific types of isotopes within a living organism, you can reduce the aging process. But the application didn't really go into any detail about that or provide any proof. The court's opinion said, we agree with the board that specification lacks any tangible disclosure of specific isotopes and defined methods for altering their abundance. Not one example is given, not one isotope producing aging is identified, nor agents such as chelating agents or substances which will enter into preferred reversible reaction with isotopes specified. Basically, the inventor didn't provide really any information, any examples. He didn't show that this worked, and he didn't really specify too much about how to control the isotopes. Example 4, using magnetic field to increase energy release of fossil fuels upon combustion. Example claim. The process of treating a fossil fuel to increase its energy release on subsequent combustion comprising passing said fuel in a fluid suspension under a pressure of about 150 to about 300 psi through a magnetic field of about 10,000 gauss for a time sufficient to substantially increase the diamagnetic properties of said fuel. This patent application, it basically says you pass fossil fuel through a magnetic field and then the fossil fuel will release more energy. The court said, considering the state of the art as reflected by the cited references, we do not believe that disclosure of the application as filed being devoid of quantitative data was sufficient to satisfy one having ordinary skill in magnetochemistry that the process as disclosed and claimed was operative. Accordingly, the examiner was justified in requiring further evidence on the issue. Since his request is not complied with, we must affirm the board's decision. Again, so the applicant did not provide any evidence. He didn't have a prototype. He didn't show experiments where this was working, that if you pass fossil fuels through the magnetic field, it increases the energy release. So the application was denied. Example 5, combustion is a matter for curing cancer. And I put in the title that this is 1964. I think some of the language in the court case was, pretty skeptical about whether anything could be done about cancer. And I think, there's been improvements in that area. So I think it would probably read a little different now. An example claim. And I just put a note that these were all composition of matter claims and not method claims. 13, a composition consisting of the precipitate formed by the dilution with benzene of the extract of cancer tissue with acetone and water present in the ratio of 3 to 15 parts by weight of the water phase to 97 to 85 parts by weight acetone, in which the materials are present in the ratio of more than 4 parts volume of benzene to 1 part by volume of the water and acetone solution. So it's kind of interesting. It's kind of saying extract of cancer tissue and then acetone, water, benzene, some kind of normal lab chemicals. The court said the defect here is that in spite of somewhat grandiose claims of appellant's specification purportedly based on actual tested experiments, not one iota of evidence has been produced, tending even to show that the tests were actually conducted. We also note that the specification does not contain a single specific experiment of which the details are supplied where any animal was actually benefited by the treatment with the claimed precipitate or serum, or where any existing tumor was caused to grow more rapidly. So again, this it's kind of a weird claim. It doesn't seem like there's a lot of science behind that, and then he didn't provide any evidence or any experiments, showing that this would work. So the application was rejected. My summary recommendations for a prototype, practical tips. You may need a prototype if an invention is difficult to believe. However, you can also use other types of evidence to prove invention is possible, like expert testimony, declarations, experiments, test results, simulations, prior supporting feasibility. Accordingly, none of these cases actually said that a prototype is needed. If they would have had prototypes, it would have overcome the rejections, but their other evidence would have been helped also. And then I also know that there are other benefits of having a prototype. If you make a prototype, it helps you refine the design. And when you refine the design, you kind of go past the basic idea, and then you get into more details. And you can use those details to have backup options for patent claims, the dependent claims. So if the patent office finds that your independent claims, the basic idea is not patentable, if you make a prototype, then you'll have more details about how you can implement the invention. And oftentimes, that those details are the patentable aspect of the invention. And then finally, I say that the other benefit is it proves feasibility for investors. If you have a prototype, then you have a working model that you can go show people. It might help with sales, might help with investors and other things. Again, my contact information is out here on the right. My LinkedIn is here. If anyone wants to connect on LinkedIn, please feel free to reach out and connect on LinkedIn. I have my YouTube channel where I have this video and other videos, and then my Gmail. All right. Well, thank you for watching the video.